swearing more than against the king.
Mr. Williams, the board would be particularly interested to hear your submissions in relation to the question of good cause and the way in which the Court of Appeal exercised its discretion in this case.
Obliged, my lord. I will therefore, I intend to begin with the issue of sentence, but I could summarize my submissions on that first, could I, my lord?
Yes.
Before going to the good cause. The sentence point is that this offense, oh my lord, I forgot, I didn't introduce my team. With me, Mr. John Clark, and Mr. Isaac Buchanan, in Jamaica, Ms. Celine Dietrich, and Mr. Rowan Pennington Benton for Respondent. My lord, the appellant was convicted before the parish court in Jamaica. At the time it was called Resident Magistrates Court. There was a change of name in the last few years. On 4 counts of obtaining money by false pretenses, which is indictable misdemeanor under Section 35 of the Larceny Act. That might be, I know that those laws were changed in the UK in the 1960s, but they still prevail in Jamaica, misdemeanors and Larceny Act. Under the Larceny Act, it creates an offense which is charged by the High Court judge in circuit with a 5-year maximum. And in the parish court, there is a maximum of 3 years for the parish court judge under the special indictable jurisdiction that the parish court judge has. And just to briefly say, there are 2 things about that special indictable jurisdiction. It's not the defendant's choice. It is the prosecutor's choice whether to charge you in the parish inferior magistrates court or to try in the circuit court. And as made out in our written submissions, there are 2 opportunities for the resident magistrate parish court judge, having consideration of the antecedents of the defendant and the nature of the offense, to move it up to the circuit court. There are 2 opportunities. The first, before he grants the order of indictment, and the second, before the Crown's case closes. He can bump it up.
If it goes to the circuit court, is it trial on indictment? Is it trial by jury?
Trial by jury,
yeah.
Yes. And by a judge of the Supreme Court. And we make the point in the written submission that the 3-year maximum in the magistrates court under the Parish Court Act, I'm going to use those interchangeably, I'm very sorry, but it's now the parish court. That 3-year maximum has been usurped, or was usurped, by the court, in this case, by ordering consecutive sentences. And
there were 4 counts on the indictment.
Indeed.
So there were 4 consecutive sentences.
4 consecutive sentences, which make it 12 years.
Do we know anything about the subject matter?
No, nothing at all, my lord. Nothing at all. Indeed, the best is that in his affidavit, Mr. Morgan said 3 related to property, and the 4th to a motor car, which he still doesn't understand what that case was about. That's what he says in his affidavit, and the Crown offers nothing further.
Do you say that these sentences are unlawful sentences?
They are unlawful. They are unlawful for this reason. It is unlawful to use consecutive sentences to circumvent the statutory maximum.
Well, it may be, in one sense, it may be inappropriate.
Indeed, it goes against totality, the totality principle.
Because of the totality principle.
Yes.
My question is rather directed as to whether the court has jurisdiction or has the power to impose such a sentence.
That's the second point. My lord is pointing me there directly. The second point is, of course, that in Jamaica we have a system where the Supreme Court is the court of unlimited jurisdiction, and the Superior Court And it is important that inferior courts, such as the magistrates' court, parish court, do not usurp the authority of the superior courts by taking on sentencing powers, which are those attributable to the superior court. So in this case, the superior court's maximum would have been 5 years. So even for the superior court, this would have been an unlawful sentence. Even more so, we say a fortiori, for this inferior court, given that it's a 3-year maximum and they're using consecutive sentences to get around it to make that point.
Can I just ask so I'm absolutely clear? When you say 3 years maximum,
Yes.
my understanding is that that is a 3-year maximum for the offence with which one is concerned.
Indeed.
So that it would be, say you had 4 completely separate offences that were not linked in any way, there would be no problem in giving consecutive sentences, would there?
There would be a problem. The first problem is we must always have in mind the statutory maximum. And in our bundle, we rely on Bridgelal and Harapashad from the CCJ and Ralphs from the English courts, and also extract from Blackstone's, which make it clear that it is incorrect sentencing practice to exceed your statutory maximum for each offence by using consecutive offences for multiple offences.
Well, that can't be right. You are allowed to give consecutive sentences.
Yes, but at common law we have a totality principle.
Yeah, subject to the totality principle.
Indeed.
But what I suppose I'm asking is, what is to tell us that this is infringing the totality principle if we've got no information about the crimes in question? Why do you say it infringes the totality principle?
Well, let me answer that in 2 ways. The first is that factually, the fact that we don't have the details of the offence cannot be used, or not to be used, adverse to the appellant. That is a failing of the state. It is his right to review his conviction. It is they who must provide the necessary information to support their sentence, whether unusual or not. And the second is the totality principle in this regard must be considered with the constitutionality of the sentence, which for Jamaica's case is even a greater principle than just mere totality. And in Jamaica's principle, there is the law, the Constitution preserves the superior court as the one to deal with serious crimes, serious offending, and it is important that the inferior court does not usurp the authority and powers of the, and there are many reasons for it. Set out quite comprehensively in Hines from this court and Davis from the Bahamas, which line on Hines, that the inferior court cannot take on the sentencing power of the inferior court cannot take on the sentencing power of the superior court, because there are protections for the citizen when being tried by the superior court. It's a more senior judge, a judge of security of tenure, etc., etc. In this case,
I would understand this submission if what the magistrate had done was to give a 4.5-year sentence on each consecutively, because the maximum was 3 years.
yes.
But on the face of it, the magistrate was acting within powers by giving 3 years for each offence, assuming that the totality principle is not infringed. But you seem to be saying, well, it's something over and above the totality principle. I'm just struggling to understand what that additional point is.
Well, the additional point that I've made is the point of the totality principle has to take into account the maximum allowable sentence for each count, And furthermore, there is a constitutionality principle which requires our inferior court to stay within its bounds. So when Parliament said 3 years is your maximum, it is not for the inferior court to...
But they haven't.
Yes, the LH count. It is not for the inferior court to shake off those shackles by saying we can do it consecutively. But perhaps I should perhaps refer the court to the Bridge-Lal case from the CCJ on this point, which makes out the point. It's at page 259 of the bundle. And it's paragraph 31.
Bear with us a moment, please, if you would.
I'm sorry, my lord?
Just bear with us for a moment, if you would. Thank you. I'm sorry, I've got a problem here. I'm sorry, just bear with me for a moment, if you would. Yes, thank you. Page
259, begin at paragraph 30.
And this is?
Bridge-Lal and Hari Prasad from the Caribbean Courts of Justice.
Starting at paragraph 31?
We could start at 31.
Where would you like us to read to?
Well, 31 does set out the principle.
Yeah.
Barring special circle, I'm in the middle of the paragraph. The sentence before says it was a mistake for the magistrate to order the 5-year sentence to run consecutively. Barring special circumstances where a person is convicted of multiple offences, which arrive at the same set of facts or same incident, it will be appropriate to impose concurrent and not consecutive sentences. That's the principle. 32, first sentence, on the other hand, consecutive sentences may be given where the offences arise out of unrelated facts or incidents. That's the principle. Then 33, consecutive sentences may also be imposed where the offences are of the same or similar kind, but where the overall criminality will not sufficiently be reflected by concurrent sentences. Then we come to the relevant section, 34. The problem faced by the magistrate was that however large the quantity of cocaine, it did not entitle her to exceed or circumvent her sentencing jurisdiction. She was not justified in imposing, in effect, a 10-year sentence on Bridge-Lal when her sentencing limit was a prison term of only 5 years.
Was that a limit of 5 years under the offence that was created, or was that a limit in her sentencing part?
That was a limit of the sentencing part for that count. If we look at
that count, right?
Yes.
So in respect of that offence, it's not a general limit.
No.
Right.
So, what you normally see is that there will be, for each particular offence, there will be a summary court, inferior court limit.
Yes.
And if it's tribal either way, there is a right. So this is the limit. But what the CCJ here is saying, you cannot use consecutivity to get around this limit. That's what they're saying. And what they're saying is that if the state thought that a longer sentence is what was required, then they should have put it in the higher court.
If one reads to the end of 34, that was a case where all the charges arose out of the same act of possession, as I read it.
Yes.
So it was the type of case to which the court is referring in paragraph 31, and not the type of case to which it's referring in 32 or 33.
Yes, on the facts, certainly it is, that is so. But the principle of how...
Yeah, we just... Is the position that here we simply don't know whether all the charges are the same events?
We don't. But there's a very important, we say a constitutional principle for Jamaica, in that the inferior court, the parish court, magistrates court, cannot be used to circumvent the order protection a citizen gets when putting a case before that lower court as opposed to the higher court. And I say these are made out by the Privy Council in Hines and in Davis. A judge of security of tenure, a more senior judge, there are other practical considerations like legal aid. All of these things are protections. And I've made a point that the parish court judge in Jamaica has many opportunities to make a decision whether or not this case will be tried by him or whether he will treat it as a preliminary inquiry committal proceedings. And it is before the order of indictment is made and before the Crown closes its case. I haven't taken you to it, but I would...
Well, surely the power, the general sentencing power of the parish court depends upon the powers given to it by the legislature, which
Indeed.
are set out at section 268,
Yes.
page 213.
Indeed.
And isn't that open to one interpretation, that the sentencing power is limited to 3 years imprisonment for each offence, as opposed to for all the offences?
The way that those provisions have been interpreted consistently is that it means that when ordering consecutive sentences, we cannot exceed that maximum.
And what authority is there for that proposition?
I just showed your lordships Bridgelal and Herefordshire. I could next take you to Ralph's, which is at page 347 of the bundle. It is
But in Bridgell, forgive me for interrupting, we simply don't know whether all the charges arose from the same facts or not.
in Bridgelal or in ours.
In Bridgell, we don't know whether
They knew in Bridgelal, but we don't know in ours. So we don't know whether any of the ordinary rules for consecutive sentence apply to ours. We're saying that's the first problem. But the second problem is...
forgive me, if the charges related to different incidents, completely distinct incidents,
Yes.
would there be any objection to the imposition of consecutive sentences of the maximum 3 years?
Yes. Because, yes, my lord, because the principle of totality regarding the consecutive sentence forbid the court exceeding the statutory maximum by ordering consecutive sentences.
So the maximum sentence that could be imposed by the parish court would be 3 years.
3 years.
For the offences of obtaining by false pretences.
Indeed.
Even though there were 10 offences.
Indeed.
And even though those offences are all entirely unconnected with each other, other than their similarity.
Well, I just don't know where you're getting this proposition. I mean, this sounds contrary to anything we know in this jurisdiction.
Well, perhaps
and we have the totality principle, and I'd need to be taken to clear authority for that proposition. The last case you gave us is certainly not clear authority. In fact, it's not authority for anything that you've so far said, because all it says is we have a totality principle, which we all accept. Yes. On your proposition, would the same apply? Well, if it went to the Supreme Court, the maximum would then be what?
5 years.
5 years. Now, are you then saying that they cannot award consecutive sentences of more than 5 years?
Yes. I'm saying so, my lord.
Even for unrelated offences? I mean, the same offence, but unrelated events.
Yes.
And we do know from Bridgelal, don't we, that it was only one event.
From Bridgelal?
Yes.
And I know, my lord, Legat has said that Bridgelal does not support my point, but I pray that your lordship will look again at Bridgelal, because Bridgelal says you cannot use consecutive sentences to get around your statutory maximum. That's what Bridgelal said. The CCJ said that in Bridgelal. And a similar thing is said by the English Court of Appeal in Ralph's, which is an Attorney General's reference. I could take you to paragraph...
I was just wondering, I apologise for interrupting, but my understanding in this jurisdiction of the ability of a magistrate's court to impose sentence, it is specifically limited. So it's not for each offence, but it is a limited overall power made expressly clear.
Yes.
Now, I would be interested in seeing the contrasting language insofar as magistrates are concerned in this jurisdiction, or in Northern Ireland, or in Scotland, to the language used at page 213, which, on one interpretation, doesn't have any such overall restriction.
Well,
And if you were able to assist in relation to that, I'd be grateful.
yes, I'll take it directly to you.
If the respondent can assist, I would also be grateful as well.
Clarify the precise question. Sorry.
Well, a magistrate's court, certainly in Northern Ireland, does not have sentencing powers in excess of a certain amount. It doesn't matter how many charges you bring and how many offences are committed. If it's more serious, you've got to go off elsewhere. And
per trial, as it were.
Yeah.
Because of course you could have multiple
yes,
on separate trials.
yeah. I would just be interested in seeing what the language is as to the use, the limit on the sentencing powers of magistrates, basically, in this jurisdiction.
I would take you to page 213 of the bundle, which shows the Judicature Parish Court Act. And just by reference, if you look across the page 212, it gives you a list of the offences travelled by the magistrate under the special indictable jurisdiction. And you can see at letter B, one of them is section 35 of the Larceny Act, which is obtaining money by false pretenses. That is page 212, I hope you all should have seen that. Then at page 213, provided that no court shall award a sentence of more than 3 years imprisonment with or without hard labour and a fine of $1 million where the conviction is for any offence referred to this section, other than an offence specified in 30 of Larceny Act, and it goes on to the other sections where I think the magistrate's power under this legislation would give 5 years would be the longest sentence magistrate would be able to impose.
In respect of any such offence.
Yes. And
That seems to be limited to the specific offence.
Yes.
yes.
It's not an overall limit.
I ask your Lordship to consider it in its constitutional framework, in that what the lawmaker is intent on doing is to take a jurisdiction which was once solely in the Supreme Court and to share it with the parish court. Although the parish court would have, as I've said, fewer protections than the circuit court would have.
But you've just indicated that the same principle applies even at the Supreme Court level.
Yes. So, but a longer sentence, 5 years,
Yeah.
but the same principle of consecutivity not being used to get around the maximum. It still applies. Let me take you, I have not yet convinced you, it's my duty to convince your Lordship on this. Let me take you to page 348, and I think I will do so with this extract.
340.
348.
Yeah, that's in Rouse, isn't it?
I'm sorry. Can I? No, but it has a very sentence. We go for it about fines. Section 29. This is a case, it's about firearm possession and so on. And this is a Attorney General's reference regarding a sentence, and the Court of Appeal is looking at the sentence. When we invited Mr. Atkinson to draw our attention to any sentencing decision which provided direct support for his submission, that in this particular case consecutive sentences were appropriate, he was unable to do so. The problem is simple. In the context of a narrow range of available sentencing powers.
Sorry, where are you reading?
Oh, I'm reading from paragraph 29.
29, thank you.
Page 348.
Right, thank you.
In the context of a narrow range of available sentencing powers, and in particular, the statutory maximum sentence, we are in reality being invited to circumvent the statutory maximum sentence on the basis that we believe it to be too low, and to achieve our objective by disapplying well-understood sentencing principles, of which Parliament must be deemed to have been aware of when statutory maximum minimum sentence was fixed. Coming to do so, that is too far, that is a step too far. And I have not read what preceded, but it's all about the ordering consecutive sentences. And what the Court of Appeal in England was here saying, we cannot get around the statutory maximum by ordering consecutive sentences.
One needs to read paragraph 29, doesn't one, both in relation to, in the context of the particular facts of that case, which we haven't yet seen, but also in the context of what has just been said in paragraph 28, which in the quoted passage from Jameson appears expressly to contemplate consecutive sentences as being appropriate in certain circumstances.
Yes.
And the last part of the paragraph is making it clear that what matters is whether these are separate events or not.
Yes. Yes. So the first point, my Lord Briggs is quite correct, that there are indeed special factual circumstances which can permit consecutive sentences, but we do not know whether they existed in this case. We know that there are rules regarding joinder of counsel and indictment, and the rules of joinder require founded on the same facts or a series of a same or similar character. So assuming that they were properly joined, they had to be founded on the same facts or same or similar character. But we can say no more about the facts of our case. What we can say is that there is a 3-year maximum on the parish court, a maximum fixed in our constitutional framework, which requires that the Superior Court do the more significant cases and hand out possibly the more onerous sentences, and that to assume jurisdiction, the parish court judge must be of the mind that his sentencing power is sufficient for that case. I did not take it to that, but I don't know if your lordships understand what I mean by that, but it's at section 272 of the Magistrates Code of Procedure, which is page 214 of the bundle. Page 214 of the bundle. And it says, the magistrate shall, after such inquiry as may seem to him necessary in order to ascertain whether the offence charge is within his jurisdiction and can be adequately punished by him under his powers, make an order which shall be endorsed on information. That's the order for the indictment. So what normally happens in our courts is that the prosecutor who has chosen the inferior court will then open the case to the magistrate seeking an order. And the magistrate has to be of the mind that his sentencing powers are adequate to deal with that offense. And then it comes again at 275, which is page 216. And if your lordships are with me, page 216, my lord. It begins with provided. It's a provided to that section. Provided shall be lawful for any magistrate at any stage of trial prior to calling on the accused person for his defense, if it shall appear to him that the accused person ought to have been charged with a more serious crime, and that more serious crime is done in his jurisdiction, or having regard to the antecedents of the accused, or the nature and circumstance of the crime of which he is accused, the case cannot be adequately dealt with him by under his powers, to vacate the order for trial of such accused person before him, and to treat and deal with the case of one for the circuit court, to the Supreme Court. So that's the second opportunity for the magistrate to say, okay, I am unable, this is a tougher case than I thought. It should be treated with at the magistrate's court. Before I leave the point, I had meant to take your lordships to Blackstone's, because I don't know whether Ralph's was as convincing as I thought it would be. But I also have Blackstone's on this point at page 502 of the bundle on the point of consecutivity cannot exceed maximum.
Sorry, page?
502.
Thank you.
This is the current edition of Blackstone's, paragraph E13.21, which is giving guidance on the use of consecutive sentences. And it speaks to a guideline, and your lordship will see ABC, which I won't, we have said that before, but in the next paragraph, the guideline states that it is not permissible to impose consecutive offenses for offenses committed at the same time in order to evade the statutory maximum penalty. Where consecutive sentences are to be passed, the judge should add the sentences for each offender and consider if the aggregate length is just and appropriate. So the point I make is that the sentence is one which usurps the circuit court judge's power to sentence in cases like this, and usurps that authority of the circuit court judge.
This principle applies in respect of offences committed at the same time.
Yes.
And we simply don't know.
We don't know. We don't know. And it would be for us, I would think, unfair to the appellant to take a worst case scenario on his approach. It is, in criminal practice, consecutive sentences are unusual, very unusual. And in fact, what normally happens is that you get one major sentence imposed and then smaller sentences, and they're made consecutive. So what would normally happen is, let us say this is 3 years, you would get 2 years, and then a few months for the others, and then you would add them up. That's what would normally happen in a case like this. To impose maximum consecutive sentences is very unusual. Multiple maximum consecutive sentences are very, very unusual and require great explanation by a trial judge, I would submit.
Well, Mr. Williams, the Court of Appeal in this case did accept that there were at least arguable grounds.
Oh, yes, indeed.
I think we'd be assisted if you could address us in relation to the way in which the court then went on to exercise its discretion as to whether it should hear the appeal despite the delay. I will
then move on to that now, my lord. I think there are some key facts on this good cause issue, and which are important. The first is that in this case, it is doubtless that the appellant did all he could to appeal. He gave his verbal notice before the parish court judge. Shortly, when he attended at the prison, when he was brought to the prison, he gave his written notice through the prison service. And through no fault of his, the problems arose. Wrong court, lateness, all the fault of the prison service, and I would say the courts. He had no assistance of counsel for over 10 years. The Court of Appeal, he had applied for legal aid, didn't get legal aid, and it is only due to a special project done by the council that he was able to get any legal assistance, 10 years after. When the Court of Appeal took his documents and stamped them, they were saying to the prison system, this man is an appellant, which meant that his time in court, not in court, his time in prison was in limbo. Time stopped running. He could not get parole during that time. He could, no day of his sentence was being served during that time. He would have been due for a 2/3 remission of the 12 years for good behavior, which 2/3 of 12 is 9, 8.
No, it's not. It's 8.
8. 8, yes.
Yes.
But yet he served 10 because he was in this limbo created by Section 31(3) of JAJA, of the Just Judicature Appellate Jurisdiction Act. I will notice different than the current English provision which currently in England, as I understand it, at the end of the day, orders are made regarding time spent. But in our situation, he remains. After 5 years, he was convinced by the Chief Justice's office, and by the Registrar of the Court of Appeal, his appeal was still good. After 5 years, he got correspondence from them. Yeah, he wrote to them, and they wrote back and said, yes, your appeal is still good. We're awaiting papers from the courts. His first time before the court was 10 years after, when we applied for bail on his behalf. And 2 years after, he would have been released if he had not appealed. And it is on that occasion for bail application that we were told, he was told, you never had an appeal to begin with. In other words, you know, these years that you have spent in prison awaiting the appeal, you had no appeal. In a situation where there has been no affidavit by the other side explaining why the records were not produced, no explanation has been given. We understand that the judicial officer is still in service. There was no natural disaster, no fire, no hurricane, which brought down the courthouse. We don't know what has happened. It's important that we look at the approach of the court. And I would, the general approach has been, I think, an admission that his constitutional rights of due process were breached. But seek your remedy in the constitutional courts seems to be the answer. We say, where the due process rights of appeal have been breached, as they have been in this case, they have been totally disabled by state agents, totally disabled, all by state agents. The answer is not in the constitutional courts to begin with. The answer is in the correctness of the conviction and sentence remaining. Because a fair appeal is important for the conviction to appropriately stand in our system. The decision of the Court of Appeal is at page 76 of the bundle. And I will make these points about the decision of the court. The first is, the appellant is being penalized for the errors of the state actors. Second, the fact that he has served his sentence prior to, or practically, as I said, served his sentence prior to the appeal, is treated as if that is an ipso facto bar to the court hearing the appeal. So, you know, you have served your sentence, so we no longer hear your appeal. The fact that he was unable to properly particularize grounds of appeal against his conviction until he was assisted by counsel is also seen to be treated as disadvantage. I don't know if my Lord saw this point in the judgment. They're saying he didn't, although he appealed against conviction and sentence, his ground as regards conviction was not formulated until later in the day, which is when he had assistance of counsel. But the point is, up to today, we have not had the record or reasons from the court. So how could he have formulated grounds without records or reasons?
Okay. Can you just show us in the judgment of the Court of Appeal where they take that point?
Oh, yes, I will. Well, let me, I will take you through the judgment very, very quickly. At paragraph 5, I'll just take key points of the judgment, if I may, my Lord. At paragraph 5, the court makes the point that he takes him on his word that there was no verbal notice, that he did give verbal notice of appeal. It's an important point. If I could just, I'll come to your Lordship's point very quickly, but this might be an advantageous way to deal with the judgment. The verbal notice point is important because in Jamaica, the argument is, or the Court of Appeal takes the position that if you do not give your initial notice and the time has passed, your appeal dies, they say, in the parish court, never to be revived.
We understand that. He's over that hurdle.
Yes, but it's an important point. And an interesting thing is, they took him on his word. The other side had the court sheet showing that he had given verbal notice, not presented at the Court of Appeal, but it is shown here. So indeed, he did give verbal notice. The paragraph 14, the Court of Appeal says the complaint about sentence does seem to have merit. Paragraph 14, the first is that the court doesn't have, these are two issues. The court does not have the RM's resident magistrate's reasons.
This is 15, is it?
14.
14, yes.
Yes, they're saying the reasons, so these are the reasons they're giving, although there is merit. The court doesn't have the learned resident magistrate's reasons for imposing consecutive sentences. We say that's the state's fault, not his fault. The second issue is that even if the grounds were...
Sorry.
Yes.
If you did bring an appeal to the Court of Appeal on the basis that the sentence was manifestly excessive, one of the factors you'd have to persuade the court about was whether or not these offences arose out of the same incident or whether they arose out of separate incidents.
Indeed.
The obligation is on the appellant to do so. And I was just wondering, what inquiries has the appellant made as to the circumstances of these offences? Well, either from the police or from the prosecuting authorities or from the counsel that previously acted for him or from the solicitor who previously was instructed or whatever?
Well, indeed, let me deal with the counsel point first. His sole ground as regards conviction was that he was abandoned by his counsel just prior to the trial and he was not given an opportunity. Now, that counsel has passed away. The other point is, once you give verbal notice of appeal, within 14 days, you are to get your record, including notes of evidence and reasons. That is the responsibility of the court to do that. So in this case, that is what he would have expected to have received like any other appellant.
Well, we are.
Yes.
That wasn't done.
Yes.
So what inquiries has the appellant made to obtain that type of information from other sources?
Well, the other sources, I don't know what other sources there would be.
Well, the prosecution is brought by the prosecuting service and presumably investigated by the police.
Yes.
So has any inquiry been made?
Well, we having written to these authorities for the record and made our appeal and made our point, it is for them we have had no response. In the judgment, they say all efforts that have been made were failed. That's what the Court of Appeal said. All, paragraph 15, the Court of Appeal says, efforts by the Crown have so far proved unsuccessful. So apparently some efforts were being made. We didn't send an affidavit on that, but efforts were made, and there we are. So it is, again, the state has all of the options and power and authority in their hands to produce the record, and they did not do so.
Who were the victims of these crimes?
I do not know, my lord.
Has any inquiry been made as to who the victims were?
Well, that would be a matter for the Crown, my lord, but on our side, we have no idea.
Is there a certificate of conviction?
Certificate of conviction? I have not seen that either, my lord. No. Yes. In fact, we did make inquiries at the parish court regarding documents, and indeed we were surprised to have seen the court sheet being produced because we had asked, we got no documents, and then we saw the court sheet produced very late in the day. Yes. And I'm reminded by my learned friend that letters were also written to the police regarding this matter. The yes, paragraph 17 goes on to say that the difficulty with submissions, with my submission, is that there is no record, and the likelihood is that there will be no record produced. The fact, and it goes on in paragraph 17 to say, Mr. Morgan's case was dealt with over 10 years ago. Laura Resident Magistrate is no longer at that court. She's now a judge of the Supreme Court. At paragraph 27, the court says...
Before we move on, are you saying these are irrelevant considerations?
Well, I don't see how these are unfavorable to the appellant, because the fact that the learned resident magistrate remains a judicial officer is telling in the fact that there ought to have been steps taken to have this record produced. And we're looking at the matter 10 years ago. It's not just 10 years ago. The first step was 1 year after the lateness of the prison, the registrar of the Court of Appeal sent the papers to the parish court and said, here is the grounds of appeal. Please prepare the record. That's 1 year after. Then 5 years after, the Office of the Chief Justice and the Office of the Court of Appeal says the records are being prepared. That's 5 years after. So, looking at it 10 years ago, we may say it may be very hard to find something I had 10 years ago. But 1 year after, could the parish court not find the records? 1 year after? And then 5 years after, when they were being convinced, he was being convinced that his appeal was still good? A paragraph...
Just before you leave it, what do you say about going back to paragraph 14?
1-4, yes. On
page 79, where the Court of Appeal says Mr. Morgan would receive no benefit from the exercise. What do you say any benefit to him would be?
The authorities, Melanie Tapper from this court and Forbes and Maharaj from this court, provide that if the state cannot provide the record, then the remedy ought to be, in a case like this, the quashing of the conviction and sentence. Because what we have here is a total failure of the appellate process.
But I don't think the quashing of the conviction is open to you to argue, is it?
For me to argue, Madam?
Yeah, my understanding is that this appeal is confined to sentence.
At the end of the day, I'm hoping that the panel will make an order quashing the sentence and remitting the issue of the quashing of the conviction to the Court of Appeal.
I think that the permission to come to the board is restricted to sentence.
It is. That is why I'm putting it that way. At the end of the day, I'm hoping to convince your lordships that is the fair result in this case, for your lordship to deal with the sentence, but to say that given the absence of the record, and given Forbes and Maharaj and Melanie Tapper, the Court of Appeal ought to take a look at whether this sentence, this conviction, ought to be maintained. That's what I hope to say at the end of the day.
But you have no permission to appeal against conviction.
That's why I'm putting it that way, to say remit it to the, that's why I'm putting it that way. In other words, send it back for them to look at that issue.
If we were not to be with you in you having any permission to deal with conviction, I come back to my question. What is the benefit of the exercise if we were purely concerned with the sentence issue?
Well, we can look at benefit in two ways. We can look at certainly personal benefit to Mr. Morgan, and we can look at benefit to administration of justice in Jamaica. So there are two ways that we can look at it. The first issue of personal benefit to Mr. Morgan is that if he were to take the matter to a constitutional court for remedies of a pecuniary nature, he would have a ruling of the court as to regarding whether his sentence was shown to be lawful or not. That certainly. But second, there is a enduring benefit to justice in public law justice in Jamaica regarding the importance of producing the record, the importance of how to treat with delays in appeals, on all the other issues which I hope to argue further in this matter. Yeah, I can't do it right now. I think the most telling paragraph in the judgment is at paragraph 27, where your Lordship may know, I haven't said it, but in our Constitution, there is a specific provision, right to review your conviction and sentence. That is section 16.8 of the Jamaica Constitution. And 16.7 provides a right to the transcript of your trial proceedings. So that those are two specific provisions in our Constitution. So at paragraph 37, in addition to the ECHR styled due process rights, you have those two additional particularized rights.
Sorry, could we go into Court of Appeal, paragraph
27.
37, thank you.
27. Mr. Morgan's right to have his convictions and sentence reviewed was lost when his appeal was deemed abandoned. The loss of that right was by way of operational relevant statute. There is no constitutional issue raised by that situation. Solution is regarded without merit. So what the court is here saying is that the fact that state actors have disabled his constitutional right to review his conviction and sentence doesn't raise any constitutional issue, and that is that. We are saying the constitutional right cannot be so illusory or so brittle that the state agents are able to terminate our rights in the manner that they did in this case. Yes. Mm-hmm. At paragraph 33, the court concludes that the appeal will be purely academic. I've explained why we don't agree. At paragraph 34, they make the point that the complaint about his legal representation at trial cannot now be treated with because of the lengthy passage of time. And too onerous for the resident magistrate to formulate her reasons. So we say that those are not appropriate considerations, because our primary point is that all of these issues are not issues which are the fault of the appellant. They're all the fault of the state. I need to take your lordships to section 268 of the 272 of the
Before you do that,
yes.
Paragraph, just trying to work out how this really fits into the structure of the Court of Appeal's judgment. Paragraph 30 on page 83
Yes.
seems to suggest that the Court of Appeal had no power to reduce Mr. Morgan's sentence.
I'm happy that my lord has raised that. What is happening there is that the court in Jamaica, in following this board's opinion in Melanetapa, normally applies a reduction of sentence as the remedy for a long delayed appeal.
Right.
I think what the court is saying, well, we can't reduce it because it is all served.
But I mean, that wouldn't appear to be right, would it? they could still reduce the sentence even though it's been served.
Indeed, indeed. But
Is that a misdirection on the part of the Court of Appeal?
it is indeed, my lord. It is indeed, because it would certainly reduce it for the record.
Yes.
Yes,
And they say the result is that there is no basis to reinstate Mr. Morgan's appeal.
yes, yes,
They had power to hear the appeal.
indeed. They had a power to hear it,
They seem, yes.
and they also, it's a case, my lords, where the statute says good cause. I shall soon take a lordship to it, but the statute says good cause.
Yes, I mean, I'm focusing here on the way they put it in paragraph 30, that said that, seems to be saying even if we heard the appeal, we couldn't reduce the sentence.
Yes.
I mean, I may be taking that paragraph slightly out of context. It may be they're addressing some different point, but it's
No, my lord, that is the point.
it's not clear to me.
That is the point.
Is it possible that what they meant is that we couldn't reduce the sentence with any practical effect because it had already been served?
Yes.
They say that elsewhere.
Yes, because they're saying he got 12 years, he has exceeded 2/3 of 12.
Possibly that's right.
I mean, he'd been released by this time.
He was released on the bail application judgment.
He was out before.
Right, so they're saying,
before the Court of Appeal.
Yes.
right, so they're saying practically, he wasn't going to serve a day more, and we can't reduce it.
So it comes back to this, whether it would be an academic exercise.
Indeed.
You say, well, it wouldn't be, as I understand it.
Yes.
The point you made about the personal benefit to Mr. Morgan.
Indeed.
That it would provide a basis on which he could then go to the Supreme Court with his constitutional motion to
Indeed.
say, as a result of these failures, I was in prison for X years longer than I should have been.
Indeed. And I figured now that we would, I know I didn't say, one thing we forgot at the start is that he also had almost 2 years prior to conviction, which ought to have been taken into account.
Yes, I follow.
So in this case, the startling thing is, it may very well have been 1 year maximum sentence that he could have received. One year. And he ended up serving 10 years. So that's the startling thing. But could I...
If the Court of Appeal did not hear the appeal against sentence and the matter then went to the Supreme Court on a constitutional application,
Yes.
presumably the judge in the Supreme Court would have to do the best that he could to work out how long had been served in prison which should not have been served.
Certainly, that would be an exercise that would certainly, but if you do have the Court of Appeal decision on that, it certainly makes litigation in the other court easier and quicker. And it certainly, and I think beyond practicalities, I know practicalities are important, but beyond them, there is something to that our rights must mean something. And if there's a right to review our conviction and sentence, I'm sorry, let me make this point. If there's a right to review our conviction and sentence, it cannot be fair that the state agents can disable that right and then say you can't enjoy it. It seems to smack in the face of saying that we have a right, where he does everything he can do. He's encouraged to, well, not encouraged, but he's certainly told after 5 years, you have a good appeal, you have a good, I mean, extant appeal. And then when he gets there, you have no appeal. If anyone deserved his day in court, it is this man. And even if his reduction in sentence order would have been a victory only for his conscience or for him to say, well, okay, you know, I've been dealt with fairly in this one, you know. Let it be so. That is what we have the constitutional rights for. You know, I know in the reply I refer to old case Secretary of State O'Brien, where Earl Birkenhead was facing a similar problem with witness. And a man had been released, is a habeas corpus after the writ was issued, and then the state released the man after the writ was issued. And Earl Birkenhead said it cannot be fair for the state to use an unlawfulness as a defense against their unlawfulness. So it cannot be that the state is saying to us, we want to maintain this conviction or sentence against you, because we are aided in so doing by our unlawful acts of not producing the record, etc., etc. That just stands in the face of our constitutionalism.
Can you just help me with a little bit of Jamaican procedure? If the appellant went to the Constitutional Court with a constitutional motion seeking compensation on the basis he shouldn't have been in prison for so long, the judge of the Supreme Court who would hear that constitutional motion would be a single judge, presumably.
Most likely, yes, madam.
And may I assume
maybe
that judge will be likely to have some sentencing experience? Might or might not.
Yes. Might or might not.
Right. And what is the avenue of appeal from a decision by that judge?
Back to the Court of Appeal.
Right. Thank you. And is it an appeal as of right or an appeal with permission?
That would be as of right. From the Constitutional Court? As of right? Yes. But
as of right from the Supreme Court to the Court on the
yes, yes. But interesting point for full court, for the Constitutional Court judge at first instance, is that he may be faced by Section 27, paragraph 27 of the Court of Appeal judgment, which says his right was terminated.
There's no constitutional issue. And
that there's no constitutional issue. So the judge might say, hold on a minute, the Court of Appeal has said this. That there's no constitutional issue, and his rights were terminated.
If we were to, going back to an exchange we had before, to confine ourselves strictly to this being an appeal on sentence, is it any use to you for us to send it back to the Court of Appeal on sentence, or are you saying it's for us to quash it or nothing?
I think that the board might find itself in no better place than the Court of Appeal regarding the issue of quashing the sentence, because there is no information regarding to support the sentence, and so I would see no benefit, humbly, in sending it back to the court for that, because there is nothing more for us to hear on that. Everything seems to have been dug up that can be dug up. The reason why I urge sending it back on the conviction is that that is an issue where I think it is, where we have endemic delays in the courts in Jamaica, in the Court of Appeal, endemic delays, which this case shows, and the other cases in the bundle, like Hugh Richards, Sylvester Stewart, which are in this bundle, show it. Ray Morgan's case isn't the only one. There are many cases like this. And unless there is an appropriate remedy for delays, one fears that the state will not take the necessary steps to resource the courts properly to treat with these issues. But to put it a different way, the courts must guard access to itself. The court must do that. And in this is a case where the access to the court, the litigant's access to the court was barred by the state. And we think, with the greatest respect to the Court of Appeal has not treated it that way.
Can I take you back to paragraph 27 of the Court of Appeal for a moment?
Yes.
Am I correct in understanding your submission to be that if paragraph 27 stands, then that could be a conclusive answer to a constitutional challenge?
It could be. It certainly would be an argument that we would have to surmount. I could see the attorney making that argument, the Attorney General making that argument.
But I wonder whether that argument would really be available to the Attorney General given the terms of paragraph 32.
Indeed, my Lord.
The Court of Appeal has ruled that he does have a right to bring a constitutional claim. So I can't see that reliance could be placed on paragraph 27.
And my Lord should also, there was another constitutional issue that we raised, which is, we're not troubled at this level, which is whether, whilst awaiting appeal, his detention was unlawful because of section 31(3), called loss of time orders. That was a major argument down below, which we have not repeated here, which I don't want to go into it too much, but basically it is saying that the loss of time order which we inherited from the UK as applied in Jamaica is now unconstitutional because you are in custody, not serving a sentence, but in custody. And that was another major point which they felt that they had no need to examine. My Lord, I wanted to take you to the...
Sorry, if I could, you at an earlier stage, and I think you've just repeated it now, said that if the state cannot provide the record, then the remedy should be quashing of the sentence, and as opposed to finding out what the appropriate sentence is or was. I entertain great reservation about whether or not one just quashes a sentence because there is a lack of a record. Where a person has committed 4 offences and there are 4 victims and there's a public interest in upholding and punishing crime.
Yes, indeed.
And if the matter does come before the Court of Appeal, is your argument, in effect, that the Court of Appeal should be trying to find the correct sentence for these offences, or are you going to be submitting that they should just simply quash it?
The trouble with absent record is that it is often a question of degree. You may have a case where you have the record of evidence and you don't have reasons, and you may be able to argue an appeal on the record of evidence without the reasons. And the Privy Council said so in Cedino and Logan, a case, I haven't put it in the bundle. But there are some cases where you have the absence so inhibits the appellate court that you cannot fairly hear the appeal. In this case, what we have is a total absence. We have no reasons, we have no record. And in that situation, it is not for the court to try to piece together through speculation or suggestion as to what ought to have transpired. Could I take you, I have referred to Forbes and Maharaj. Could I take you to it? It's at page 279 of the bundle. It's a decision of the Privy Council from Trinidad and Tobago in 1998. And I believe it does answer the question my Lord Stevens asked.
279.
Page 279, which is page 489 of the judgment, letter F. The matter was principally argued was the effect of the failure of the magistrate to comply with statutory duty to state his reasons. And if your lordships are with me there. In this connection, their lordships were referred to Alexander and Williams. Their lordships were informed that that case had been cited before the Court of Appeal in the present case, although it is not considered nor mentioned in their decision. The judgment in that case clearly recognized the fundamental importance of the furnishing of reasons, particularly in circumstances where the deprivation of liberty is at stake. The question debated whether failure to provide reasons would necessarily lead to a quashing of the decision, or whether in at least some cases the failure would not be fatal. The lordships do not consider that the present case provides an appropriate occasion to resolve that question. It's sufficient to observe that without the statement of reasons, it would usually be impossible to know whether the magistrate has misdirected himself on the law or misunderstood or has misapplied the evidence. The absence of reasons at least enables an appellant to argue from a strong position that there cannot have been a sound reason for the decision in issue. But even if cases may occur where the failure is not fatal, their lordships are satisfied the Court of Appeal was in error in proceeding to review the record in order, as they put it, to see if there is sufficient evidence of which the magistrate could have come to the decision at which he arrived. As expressed, that places too low a threshold for upholding conviction. I could also take your lordships to English and Emery
This seems to be said in the context of a conviction rather than a sentence, doesn't it?
Yeah, but I would, the appeal was against conviction and sentence, and I would...
But the powers of the court on an appeal against sentence
Yes.
are rather more flexible, are they not, than the powers of the court on an appeal against conviction?
Different?
In the sense that if it's
different,
I'm assuming, but you must tell me if I'm wrong.
I would say different, but not...
The appeal in Jamaica has power to substitute a different sentence from the one imposed by the court below. Yes.
It's a different approach, but the court will say the sentence manifestly excessive against principle, contrary to principle, which we say in this case. In some other way, unfair, sentencing procedure was unfair. Those would be the considerations. And if you are going to so you would have to know what are the factual reasons for the sentence, and what is the reasoning that the trial court employed to arrive at a sentence for you to conclude whether a sentence ought to be quashed. Here, we cannot know we do not know the factual circumstances, and we do not know the reasoning that led to the sentence. And it is an unusual sentence. It's a most unusual sentence. I want to just reiterate the point regarding absence of reasons. And I would take you to page 537 in the bundle, which is English and Emery, a decision of Lord Phillips, and I believe it's the Court of Appeal.
I'm so sorry, could you give me the page number?
537.
537?
Yes.
Thank you.
537. And at paragraph 1, Lord Phillips is looking at a situation where the ground of appeal, a civil matter, nevertheless, but the ground of appeal was a failure to give adequate reasons for the decision. In that case, the judgment was 29 pages long, but seemingly in those 29 pages, no reasons. And the court, at paragraph 2, Lord Phillips says, I'm at the second sentence. The rights of appeal that are afforded on a statute reflect the fact that no judge is infallible. It should, however, be possible to deduce from a judgment the reason for the judge's decision. And he goes on to say that, happily, the rash of applications for permission to appeal based on the decision in Flannery's case does not reflect a widespread inability or disinclination on the part of the judiciary to explain the basis for their decisions. Yes. And at paragraph 6, he further refers to the case of Knightsbridge Court, ex parte International Sporting Club, a judgment of Lord Justice Henry. The duty is a function of due process, the duty to give reasons, and therefore of justice. Its rationale has two principal aspects. The first, that the fairness surely requires that the parties, especially losing party, should be left in no doubt why they have won or lost. This is especially so since without reason, the losing party will not know, as I said in ex parte Dave, where the court has misdirected itself, and thus whether he may have an available appeal on the substance of the case. So it's important for the losing party to be able to look at the reasons and formulate and get advice on his grounds. I turn the page, and I go on to say, I'm at page 539 now, top of the page, where because no reasons are given, it's impossible to tell whether the judge has gone wrong on the law or the facts. The losing party would be altogether deprived of its chance of an appeal unless the court entertains an appeal based on a lack of reasons itself. And at paragraph 7, my Lord Phillips says it applies equally to the Magistrates Court as regards the European Convention of Human Rights due process principles. We would say because of Jamaica adopting such principles, and also because of a right to review our conviction. At paragraph 15, Lord Phillips says at letter E, reasons must be given, and it says, while a constant refrain is that reasons must be given in order to render practicable the exercise of rights of appeal. And so, I know my Lord Stevens is concerned the fact that there was indeed a conviction and victims, but our process of trial in Jamaica includes an appeal system, and in that appeal system, it must be fair. And otherwise, we cannot say that a conviction was properly made out, or a sentence, unless, as required by statute, we have the reasons properly prepared. I was taking your lordships to the actual statutory framework for the reasons and the appeal regime. I would just take your lordships.
One just assumes for one moment there are no reasons, that none were given, or there are none available. All you do, the only thing that the Court of Appeal can then do is impose the sentence that is appropriate for the particular facts of the case.
I could have, yes.
And in doing so, in carrying that exercise, presumably if there is a lack of any evidence as to, for instance, the amount of money that was stolen, then they have to proceed on a basis which is most favourable to the accused.
That's what we're saying, yes, ma'am. The appeals from the Parish Court of Jamaica, I try to take it to page 224 of the bundle. Let me start at 223. Page 223 gives you 293 of the Judicature Parish Court Act as it's called, and it does show that appeals are as of right.
This is which section?
293.
293, thank you.
Okay, yeah, let me go back. Before I go to 293, I should have also referred my lords to 291, which is at page 222. And at 291, there is the third paragraph in that section, wherein a person charged before a court with an offence specified by the minister, by order to be an offence which this paragraph shall apply, if found guilty of such offence, the magistrate shall record or cause to be recorded in note of evidence a statement in summary form of his findings of fact on which the verdict of guilt is found. Now, this refers, we did provide the Gazette note, which shows that this offence is one of those where the minister ordered in 1974 that the magistrates must provide reasons. We're saying that, you know, in addition to the constitutional requirement, it's required in statute. That's 294, and the Gazette note is in our bundle. So, and if you go further down, the two paragraphs below that, notes are to be taken in a book. Such book shall be preserved in the office of the clerk, and so on. And reference to the same shall be noted in the fold of information. So there is a system that ought to be maintained for the maintaining of these records and notes. And again, my lords, I know we're saying it was 10 years, but it was 1 year when they first got their reminder. And there was, as I've said before, there was neither fire nor flood, nor earthquake, or anything that could have disrupted the court during that time. No natural disaster. So at 293 is the right. 294 says you can do verbal notice or written notice. 295 says if you don't give your notice, it's seized and determined. Now, it doesn't affect us in this case, but at the point I just want to make very briefly is that the Privy Council said that such inflexible time limits may offend the Constitution in Hamilton, but it seems that the Jamaican Court of Appeal have hearkened to Hamilton, and they have continued to maintain hard, inflexible time limits in some of the cases that we put in the bundle, like Hugh Richards. This is mentioned. These hard time limits, inflexible time limits, despite what the court said in Hamilton. But if we go to 296, which is the section of import, I'll first deal with the proviso. I'm going to come back to it for the other section, part of it. But the proviso says, the Court of Appeal may in any case for good cause shown hereon determine the appeal, notwithstanding the grounds of appeal were not filed within the time prescribed before. That is the good cause provision. A point I would like to make regarding that is this. It is important, I would submit, for the court not to be seen to condone improper, unlawful, unconstitutional actions by the state agents. Not to be seen to condone it. Concern must be had as regards to the reasonable person looking on. And the reasonable person looking on will say to themselves, here is a man, despite whatever he was convicted for, whose appeals have totally been blocked by the state, and the court did nothing about it. It's how a man looking on would say. And so it is important, and this is an issue that I should have made earlier when I was asked a question about the benefit to hearing an appeal of this nature, beyond the pecuniary or personal benefit to Mr. Morgan. On the point of mootness, my lords, I did make the point that the Court of Appeal treated it as an absolute bar. The fact that they said, they were saying, you have served the sentence, so that's it. We cannot hear the appeal. And I know that there is some dicta from this court in Moss that that it is unlikely that the board would hear an appeal once the sentence has been served. Obiter dicta, and certainly not an absolute bar, just unlikely. I would, in the bundle, I have referred to two cases, one from Canada's Supreme Court and the other from the CCJ regarding mootness. And one is Smith, which, and the other is Yaakache from CCJ. Smith from Canada and Yaakache from CCJ.
Can you give us the reference to?
Yes,
please.
I have Smith being at page 1157. Let me just make sure if I have a right note. Yes, Smith is at 1157. Is that the back of the bundle?
Yeah.
Yes, I think it's the last case in the bundle.
Yes.
Yes.
Yes. And Yaakache, I think that's a Mayan word, I'm trying to pronounce it properly. Is it at 375, I have it at the bundle?
I'm so sorry, page?
375.
375.
It's Yaakache, it begins at 371. Yaakache Conservation Trust. Both are public law cases. Death of appellant in one, the other, the public law issue was no longer extant at the time of the appeal. And these are the tests which I derived from both. Could I say, my lords, that we're taking to it, I derived these from paragraphs 45 to 50 of Smith and paragraphs 4 to 6 of Yaakache.
46 or 426?
45 to 50
yes,
of Smith and 4 to 6
Thank you, I thought so.
of Yaakache.
Yeah.
So these are the points that are in favor of hearing a moot appeal, an appeal where mootness arises. Do adversarial parties remain? So in other words, will the court be only hearing from one side, which in private law matters that can sometimes arise? There is no more contentious issue, so therefore there is no need for hear both sides, for both sides to appear. Strength of the grounds is issue also raised. I should say, of course, we certainly have adversarial parties in this matter. The state is present. We believe, and it was never doubted, that the appeal against sentence appears to be meritorious, so strength of grounds. The third thing raised in both is the public importance of dealing with a systemic issue related to the administration of justice. And we here say the systemic issues are the access to the court, the sentencing power of the parish court judge, and the potency of the rights to review our convictions and the right to receive a transcript of our trial proceedings, which are 16.7 and 16.8 of our Constitution.
But is there anything in the materials before us to suggest that the particular way in which, as your opponent concedes, your client has been let down by the system in this case is a systemic issue?
Well, indeed, we see where there are a number of authorities in our bundle of similar cases. I would refer to Sylvester Stewart and Hugh Richards, and indeed we don't have it with us now, but indeed in a recent report of the Court of Appeal, they did refer to delays as being a problem that they are confronting at the court. So it is, I think, and if needed, I could provide to the court the latest report of the Jamaica Court of Appeal, where it touches on that issue.
The issue of delays is rather different from the particular failings of the system that you've identified in this case.
Oh yes, indeed, because this is delay plus. This is delay plus state. Well, ordinarily at the appeal court, state is the prime actor for the cause of delay. But it is delay plus injustice, delay plus misdirection. It's all no reasons. You know, so it is it's like a Godzilla of delay. I mean, the delay on steroids. There's also public interest in demonstrating the court's stance on delay and access to the court. And the final point on mootness, which I think I would with respect, commend mostly, is that the Yakache and Smith say, where the issue is a recurring one, likely to become moot before an appeal can be heard, that is also an indicator of when the court should hear it. Now, I say that because the parish court in Jamaica ordinarily gives short sentences, ordinarily. And if you have many years delay in your appeal being heard, it is often going to happen that you are going to have, if you do not get bail, that you are going to have your sentence expired before your appeal can be heard. Like, think of a typical, before independence or at independence, there was a 1-year maximum on the inferior court. Now, I think 5 years is, I think, about the limit in Jamaica for any particular offense that court can give. In a delayed situation, it may well be that magistrate court sentences will always be served before appeal court can hear it. And I should throw into that, my lords, this particular problem in Jamaica, that there is no bail pending appeal for persons who were not on bail at trial. So you were at your trial, you didn't have bail. You're at the Court of Appeal now and your appeal is long delayed. There's no bail for you at that level.
Have you got a single case in which this problem has previously arisen in Jamaica?
Indeed, my lord.
That is of an appeal document being lodged with the prison authorities but not being forwarded. Is there a single case?
Yes, there is Hugh Richards, right, which is in our bundle.
Yeah.
There's also Sylvester Stewart, where in our bundle about reasons and records not being produced after long delays.
Right. So can we just have a note of those cases, please?
And I'll give you the page numbers for both of them. Sylvester Stewart and Hugh Richards. In fact, Hugh Richards is the case which was followed by the court in Ray Morgan in not following the American prison mailbox rule.
So Hugh Richards, which is the other case?
Sylvester Stewart.
You have the page numbers for each.
Which one?
Hugh Richards.
Hugh Richards at page 300. Sylvester Stewart. Sylvester Stewart, here it is, page 853.
So Hugh Richards was a conviction before the resident magistrate.
Yes, madam.
Right. Okay.
Which is eerily similar to our case, my lord.
Yeah. Okay.
To close off my argument on good cause, could I say, my lord, that I think your lordship's opinion in Hamilton from Jamaican Court of Appeal does make the points that I would like to make regarding what is good cause. And at paragraph 15, at page 289, Hamilton says, the fair hearing principles apply to appeals. I will say more so because Jamaica has actually included a right to review your conviction. At paragraph 15, they also say the state cannot impair the very essence of the right. and there is no greater impairment of the right than in this case where the state has disabled the right. Practically. There are general rules made, longer the delay, the more convincing and weightier the explanation. That's paragraph 17. But the point is, that can't apply to my submission where the appeal delay is the fault of the states. It is not the defendant's appellant's fault, it's the state's fault. And that the general principle is stated at paragraph 16. That the general principle is, what does the interest of justice demand? And I know I've mentioned Sylvester Stewart.
You've mentioned Hamilton before in connection with section 294.
Yes, my lord.
Is it a case on 294 or 296?
Hamilton was actually a case on the Privy Council's own rules regarding how long it takes to, yes.
Yes, I understand. Thank you.
I would just, I know I said finishing good cause, but my note tells me that I must take you to Sylvester Stewart. And so I take you to it now. At page 853 of the bundle, I won't be long in it because this is another decision of the Court of Appeal of Jamaica in 2017. Again, this is a delay of many, many years in the hearing of the appeal. I note that at paragraph 9, my lord, the last sentence, no power to extend time, where 294 not complied with, we say that is contrary to Hamilton, but we pass on it, and they deal with that extensively. But at paragraph 16 to 20, the Court of Appeal of Jamaica deals with the issue that my lord Stevens raised earlier. Paragraph 16, in instant case, the matter could fairly have been dealt with on the available documents that constitute the record and on the relevant section of the Act. However, it is not impossible that in another case with different facts, where notes of evidence were absent, the absence of notes where no fault of the non-production could be blamed on the appellant or applicant could possibly result in a different outcome depending on circumstances. The delay in this application being heard, for example, due large number of notes is a cause of concern and so on. So the Court of Appeal did signal in 2017 what the approach ought to be where absent records reasons disable the appeal. So I do take it to that. But, my lords, we are in the position of arguing good cause when in our respective submission we ought not to have been, because we did everything that we could have done to file our appeal in time. And it is the state who put us in the position from arguing as of right to be arguing as of arguing to show good cause. So the next part of my submission to you will be to show, hopefully, that the Court of Appeal was wrong to say that our appeal had been terminated because of the late filing by the prison authorities of the grounds. Now, I know your Lordship will know the background to this quite well. The man is in prison. In his first month in prison, he cannot have contact with the outside world. All contact must go through the prison authorities, through the superintendent of prison, who is in fact a justice of the peace, making a minor judicial officer. He keeps records. He's required to keep records of everything that happens in the prison. The prisoners are bound to send correspondence through him. At common law, we have Raymond and Honey, which makes the point that it is likely to be a contempt of court if the prison officials fail to forward documents to the court. So there is a common law duty to forward the documents. But we say it's greater than that. It's a constitutional duty. We'll come to that shortly. But first, let us see how we got into the problem that we did. And it's at page 224 of the bundle. Because our argument is that when Mr. Morgan delivered the documents to the prison official, that was sufficient for Section 296 of the Act. So, Section 296 says, notwithstanding anything contained in any law regulating appeals from judgment of a magistrate in any case tried by him on indictment or information by virtue of special statute of jurisdiction, the appellant shall within 21 days of the date of judgment draw up and file with the clerk of the courts for transmission to the Court of Appeal the grounds of appeal, and on his failure to do so, he shall be deemed to have abandoned the appeal. Looking at this grammatically, my lords, I would suggest that two things stand out. First is that the clerk of the courts is passive. Second is that the active person in this is the appellant. And the failure which ought to lead to his appeal being deemed abandoned is his failure. That's what the section says. His failure to do so shall be deemed to have, the appeal shall be deemed to be abandoned. So in this case, it was not his failure which led to his documents being misdirected and out of time. It was the state's failure. Now, there is, as I pointed out that in Jamaica, our Constitution provides for this right to review conviction. And I would take you to page 575 of the bundle, to the case of Jamaicans for Justice and the Public Service Commission, where the board opined on the nature of constitutional duties on state actors in Jamaica.
Sorry, could you give the page?
Yes, page, I'm going to take it to page 573.
573.
Yes, my lord, which is right in the body of JFJ versus PSC.
573, paragraph?
Paragraph, we can begin at paragraph 16.
Thank you.
page 573, my lord. Before the Court of Appeal of Jamaica, the issue was whether the Public Service Commission had the duty to consult with INDECOM, a government police oversight body, before dealing with the promotion of superintendents and other officers in the police force. So the question is, could they? Second question is, did they have a duty? That was the question. And the argument was they didn't have a duty because their statute didn't say so. And what at page 20, the fact that paragraph 20, I think this is Madam Justice Hale, said that they do have the power to call for the report. The second sentence is the issue whether there is a duty. And at paragraph 23, they make the point that the state has the responsibility to act in a manner compatible with fundamental human rights. And that duty at paragraph 28 meant that they had to act compatibly with human rights. I make that point, my lord, because a person can find themselves in police custody, in police lockup custody, after conviction in the Magistrates Court or in the Department of Corrections. It's a short sentence, you may serve it in the lockup in the parish or some other parish nearby. In a long sentence, you come larger to Kingston or to Spanish Town, and you serve it at the big prison if it's a longer sentence. So it's a point to be made that either the police or the prison authorities have a duty made under the Constitution to facilitate exercise of your constitutional right to review. So if I were at the lockup in, let's say, Lucy, which is far west, and I were to give my notice of appeal to the officer, he cannot laugh at me and not take it. He has to take it. And he has to take it and he must deliver it. That's the point. And similarly, even without any statutory provision. And I know in the argument we refer to some statutory provisions. I think it's not a good use of time for me to belabor them because they're in the written provisions, but just to say that there is a constitutional duty to serve these documents. We locate the duty and we locate the practicality of it. Now, what the Court of Appeal is saying in Jamaica is that once the prison officer misdirects, it is the inmate who suffers the ramifications of that. In other words, it is the inmate who it is as if the prison officials are the inmate's agents, and we are saying that is palpably unfair. In the Hugh Richards case, at page 300, the Court of Appeal was asked to consider an American solution, which comes from Houston and Lack. And they have even given it a very nice name, calling it the prison mailbox rule. And Houston and Lack is at page 292 of our judgment, of our bundle. And they were in fact following their older decision in Fallon. Between Fallon was a criminal case. Houston and Lack is a habeas corpus case, which was civil. And there seems to have been, the minority seem to have had some difficulty following Fallon in a civil case. But here we are in a criminal case. The point for Houston and Lack is that the inmate who is pro se, who has no legal assistance, have unique disabilities. They have no control over the prison authorities. And delivery to the prison officials for forwarding could amount to filing. And that filing is not a word within a precise definition. Now, we say that Houston and Lack does provide an answer which could be applicable to Jamaica. And these are the reasons. If your lordships go to look at Hugh Richards at paragraph 34 of Hugh Richards. Hugh Richards, as I've noticed at page 300, in Hugh Richards, the court recognized the problem, and that paragraph 34, they say, oh my, this is a problem, but we need Parliament to intervene. And they say, at paragraph 34, the court is therefore not inclined to agree with Mr. Equiano in respect of his interpretation of the term give. They're referring to give because they were referring to give notice of appeal. As in section 24, could include delivery to the prison authorities. It recognizes our interpretation may have grave results. They recognize that. It also recognizes that Mr. Richards' case may not be unique. They recognize that. It would seem, therefore, the situation requires statutory intervention. So they're saying that when it comes to access to the courts, they recognize that there's a serious problem here, but they're leaving it for Parliament to treat with. Well, Hugh Richards is some years ago, but Parliament has not taken this up in any way. This is 2014, that is nine years ago, and Parliament has not taken up the issue. We say that the courts are not so impotent to be able to not be able to protect access to itself. Don't have to depend on Parliament, because we have a constitution which requires interpretation of statutory provisions in favor of human rights, in favor of access to the court. I have referred in the bundle to a Caribbean text on Caribbean constitutions, which makes that point. At page 478 of the bundle, there is fundamentals of Caribbean constitutional law, which makes that point. I also refer in the bundle to Benyon about interpretation to avoid absurdity.
And the reference to Benyon?
I'm sorry, it's at page 498.
Thank you.
I make up to make this point. Not only is it unconstitutional to deny access in this way, to accept an interpretation that denies access, when there's an interpretation which can permit access, it is also absurd to do so. It's absurd. Parliament did not intend to have state agents be able to deny access to the courts. Parliament did not intend that. This is an absurd result. The board has previously, for example, in Lovelace from the Bahamas, and Lovelace is at page 314, interpreted a provision which said there was no appeal from the capital penalty. No appeal from that. I'm sorry, not no appeal, but no extension of time for appeals from the capital penalty. And the court the board in Lovelace says that it's plainly unconstitutional. In the criminal appeal itself, it's plainly unconstitutional, and we're going to strike that provision down.
Sorry, which paragraph do we see that in Lovelace?
In Lovelace, paragraphs 11 to and 12.
Thank you.
And similarly, the Eastern Caribbean case of Canonier was also relied on in Lovelace. At paragraph 24 of Lovelace, the board said the provision regarding access to the court must be interpreted to comply with the Constitution. You must interpret the provision to comply with the Constitution. So, the clerk of the courts, I myself was a clerk of the courts many years ago, that person is also a prosecutor. So the person prosecutes and runs the court's office. It's like prosecutor and registrar mixed in one. And that person has deputy clerks and assistant clerks who assist them. So the who are normally outside of court doing this kind of work. So if the clerk of the court was to say, I have set up a new system, perhaps COVID system, you're going to email me all documents. It would be when I send the email, would be not when the clerk deems to open his email. It is my last unilateral act. If the clerk were to put up a little post box at the door and say, just push it in one of those and I'll look at it later. Or if the clerk was to say, assistant, you collect and I'll check later. None of those we would say. We would never say filing means when the clerk himself puts that document on the official court file. We would never say that. We would always look at the time in which, the moment in which the appellant did his final act, noting, as I've said before, that the section says his failure to file the appeal, file his grounds. Did I point it out to your lordships?
You made that point. Yeah.
I did?
You did.
Yes. In that mind, I would also refer to two English cases which I believe assist this point. The first is Public Prosecutor's Office and O'Connor, which I believe that my Lord Stevens wrote that judgment, where...
Sorry, the name of the case?
Public Prosecutor's Office versus O'Connor.
Thank you.
It's at page 324.
Thank you.
Of the bundle. Just the key points that I take from it. It's a question about service out of time, whether the fugitive extradition person would be penalized for his counsel's failure. And I would say his counsel, it would be more his agent than the prison officials would ever be. And my Lord Stevens says the interpretation question at paragraph 5 and at paragraph 20 that the mischief for time limits is for certainty and speed, but not to disable anyone wishing to do so. That is not the purpose. At paragraph 35, my Lord Stevens said so. The purpose is not to disable the appellant from making his appeal. And the surrogacy principle that the...
Sorry, that's paragraph 20, is it?
35.
Sorry, just could you give us the paragraph and the page, if you wouldn't mind?
Oh, the page. Let me just quickly tweet them.
Paragraph 35.
So I had said interpretation question is at page 327. And that my Lord Stevens says we must interpret to avoid unfairness.
So, sorry.
So page 327, paragraph
5. Then the next I took your lordships to is at paragraph 20, where my Lord Stevens considers the import of time limits.
I'm not sure paragraph 5, was that the reference you doesn't?
It doesn't.
I was at the paragraph 5.
It doesn't refer to, doesn't quite state the proposition you put forward.
At paragraph 5, my Lord identifies
the issue.
That the issue is how the section should be interpreted.
I see, yes, okay, just that. Okay, and then
that's the interpretation question.
And then paragraph...
It sets out the positive purpose of the short time limit.
Yes.
Where?
And I think you went on and said that Lord Stevens also said it wasn't there to discourage or disable appeals. Where do we find that?
Yes.
At paragraph 35.
35? Thank you.
The very last sentence of 35. At paragraph 38 and 50, my Lord Stevens says you cannot blame the man for his lawyer's error. And we say A for Torah in this case where it is a prison's error. At paragraph 49, paragraph 49 is a long paragraph, so could I say 49 letter G, beginning with furthermore? It's page 338, my lord, I'm sorry. where my Lord, if I summarize it, my Lord saying it's not the purpose of legislation to perpetuate the potential injustice which could result from lack of access due to the fault of the person's legal representative.
Sorry, you're reading at page?
Yes, same page.
49G.
49G.
The bottom of the page.
I'm beginning it from the word furthermore.
Yes, thank you.
And at paragraph 51, my Lord says that it's no benefit to the man to say he can sue his lawyers later on. I would apply it in this case. No benefit for Mr. Morgan to say he can sue the prisons or the state.
Well, there's no benefit in the concept that he would have been subjected to inhuman and degrading treatment if he had been returned.
Indeed.
And so he would have been in a different country and subjected to a prison system that was inhuman and degrading.
Indeed.
And somewhat a little bit different from here.
But may I say, my Lord, the larger point I think your Lordship is making is that it is, he has done all he could to engage it.
Yeah, no, that point's the same.
Yes.
That's the point, the same point. Right?
And you're saying...
He'd done everything he could do in order to lodge his appeal.
Yes.
The fault was entirely the fault of his lawyers.
Indeed.
And
we're saying, if we're to arrive a case like this, where it's not the fault of his lawyers, but the fault of the state.
yes.
And of course, your Lordship was following, I believe, Lord Mance in Pomichowski, of which I would commend, I know I'm kind of running out, I commend paragraphs 35 to 39 of Pomichowski, which is at page 605. Where Lord Mance said, without taking you to it, that finality is important, but it cannot disproportionately deny access to the appeal. That is wrong, Lord Mance said. And you must read the provision in a manner consistent with the Convention rights. Parliament did not intend injustice. That's paragraph 35 to 39 of Pomichowski, where Lord Mance said that, which, yes.
Mr. Williams, it's time to draw your submissions to a close, I think.
Yes, my Lord, yes. I also would comment to your Lordships very briefly the Van Aken case, page 700 to 702, where communication by the method held out was deemed sufficient communication. So, finally then, my Lord, I will conclude in this way. That we pray that the board will find that the sentence is manifestly wrong in principle, as being usurping the Supreme Court judge, exceeding statutory maximum, and not taking into account the 2 years almost awaiting trial. And that regarding the test for good cause, the appellant cannot be penalized for state failures.
How long was he actually in custody? Was it 18 months before?
We have it as 2 years, but I've heard...
I've seen it variously expressed as 18 months or 2 years.
I see my reference says 18 months. We always have those 2 years, but...
I think the appellant's affidavit says 1 year, 6 months,
Yeah.
7.
Oh, when 18 months, we'll accept that, my Lord, yes.
Yes.
We also say importantly, my Lords, for jurisprudence in Jamaica, that there is a duty on the prison and police officials to deliver these items, these records, documents, to the court and that once the inmate does his last act of turning it over to the police prison official, that should provide for filing under the Act, comply with the requirement for filing under the Act. And we also ask the board to find that where the state failure makes the hearing of appeal difficult or impossible, conviction or sentence cannot stand. At the start, I said I was going to pray that the board would recommend the quashing of the sentence and remitting of the conviction. I hope that I have successfully convinced that that is the appropriate orders. Unless there's any questions that Your Lordship would like to ask me. There is a postscript in our case dealing with issues of orders that could be made generally for jurisprudence in Jamaica regarding delays. And there is one particular approach in Canada where after a particular period of delay, the state has a duty to show that there can still be a fair trial or fair appeal after a certain period of delay. Something that we would urge, and in the Jordan case in Canada, they have done that to much great effect in Canada in improving delays. It's a kind of thing which a final court can do, make such orders, and we would, it is our postscript of our case, we'd urge that the board would consider such measures to assist in alleviating the problems in Jamaica. And if I can be of any further assistance.
Thank you, Mr. Williams. We're grateful. Mr. Pennington-Benton.
Thank you very much, my lords. Perhaps I could just outline my intended structure of the submissions. I won't be very long. It's the first piece of good news, I hope, to give your lordships, because largely, with respect, there are large parts of the appellant's case that we accept and support in as much as there should be recognition that something badly went wrong in this case, and the system, as my Lord Lloyd Jones said, did fail the appellant. But my Lord, the order in which I want to cover things, if I can, please, is to deal with them in three essential issues, divide them into three essential issues. The first issue is just to get clarity on exactly what went wrong in this case and why. And the purpose of that is just to identify and assist your lordships insofar as your lordships are minded to provide guidance in the judgment as to how this sort of thing could be avoided in the future. The second issue is the first part of the remedies case, really, whether or not the Constitution requires Section 296 to be read as, rather than filing grounds of appeal with the clerks of the court, that should be read as filing the grounds with the prison authorities. Whether that's necessary in this case and whether it's an appropriate use of a constitutional court's powers. And then thirdly and finally, I will deal with the question of remedy in this particular case, whether or not the Court of Appeal was justified to make the orders that it did. I realise I'm probably saving the most controversial thing till last, but I will deal with it, and there is a reason why I'm proposing to take it in the order that I'm taking it. So, my lords, we've already been through, so the first issue is what went wrong. We've already been through some of this material, so I don't want to repeat it, but it is plain in this case, and the Court of Appeal accepted that oral notice of appeal was given. So we are not in Hugh Richards territory, because there is not an inflexible fixed time limit. So we're not in Lovelace or any of those other cases territory. It's clear as well, I accept, that the appellant gave his grounds of appeal to the prison authorities. So I accept, therefore, that he did all one could reasonably have expected him to do. the grounds of appeal were not filed with the clerk of the courts of the magistrates. I accept that that was not the appellant's fault. They were filed in the Court of Appeal in error. So that's the first error. The second error, which I accept, is that the magistrates' court, now parish court, failed to send the record, notes of evidence and so on and so forth, up to the Court of Appeal. Lords, I know we've been through these provisions already, but just very briefly, I would ask your Lordships to turn them up. It's 223 of the bundle.
223.
223. Actually, starting on 222, you'll have seen this. This is the requirement to put together a record of evidence and notes and so on and so forth. And then on 223, you've got section 293, which is the appeal as of right. Then 294, any person desiring to appeal, etc., must give verbal notice of appeal or written notice of appeal. And then 295, your right of appeal is lost, according to the statute, if you don't file a notice of appeal or give oral notice of appeal. And then we're obviously dealing with section 296. And then over the page onto page 226 of the record, this is section 299 of the statute. The clerk of court shall not later than 14 days after the receipt of the notice of appeal forward to the registrar the record of the case. Now, what seems to have happened in this case is oral notice of appeal in the magistrates' court, that should trigger the 299 obligation to send the documents up. But because an appeal is deemed abandoned under section 296, if the grounds of appeal aren't filed, I think the practical reality is, I think this is I infer this from the judgment of Brooks, President, in his bail judgment, is that the magistrates' court effectively waits, because if the appeal is being abandoned, deemed abandoned, then what's the point in sending all of the material up to the Court of Appeal?
But the clerk has to send to the Court of Appeal within 14 days.
Yes.
There's 21 days allowed for lodging, for filing the grounds of appeal.
Exactly.
So he's not entitled to wait.
Exactly. And I think that's, I can't be sure that that's what's happening, but I suspect what is happening, and this is, I infer this from something that's said by the President in the bail judgment, is that effectively magistrates will say, well, look, if this appeal, if we don't manage to get the documents to the Court of Appeal within 14 days, which may well happen, we then don't get the grounds of appeal. Well, it's been abandoned. So therefore, what's the point in sending the record? But of course, the essential
Are you standing over that practice?
Sorry?
Are you standing over that practice? Are you saying it is one that should be endorsed by the board?
No. I'm saying I can't even be sure exactly what is happening, but I infer that that may well be what is happening, because once an appeal is deemed as abandoned, you think to yourself, well, we're late. If we're late in providing information, what's the point in providing it now? So the first piece of guidance, insofar as your Lordship's board is minded to give any, is to say that the magistrates' court must send the record, even if it is late, and even if they don't receive the grounds of appeal. And the reason for that, of course, is because a defendant may make an application to abridge time effectively under section 296. In other words, they may seek to invoke the proviso. So what should happen is, as soon as notice of appeal is given, or as soon after there is practical, documents are sent up to the Court of Appeal. Even if the grounds of appeal aren't filed within 21 days, so that the appeal is deemed abandoned, nonetheless the Court of Appeal has the documents, so that when an appellant realises that his appeal has been deemed abandoned, he can go to the Court of Appeal with his documents already there and say, please hear my appeal anyway. And in that way, we won't get left in a situation in which years after the event, the Court of Appeal has to try and piece together what happened. Well, what's just related to this point since we're here is Form B1, which is at page 21 of the bundle. In this case, this is the criminal appeal form.
What did you say, 431?
It's page 21.
So sorry.
21 of the record. This is the criminal form B1. It refers there to Rule 3.31A of the Court of Appeal rules. I think this is actually the form that's used, I believe, for appeals also from the Supreme Court to the Court of Appeal. And the difficulty is that it's the same form that's used for notices of appeal and for grounds of appeal. Of course, one can see how potential practices may have developed in circumstances where you're using the same form basically for everything. First of all, to give your notice of appeal. But then, of course, if a defendant doesn't give oral notice of appeal, the Magistrates' Court is going to be expecting this document anyway. First of all, to give notice of appeal in writing, and second of all, with the grounds.
So he's given a form which is addressed to the Registrar of the Court of Appeal, and it should have been addressed to the Clerk of the Court.
Doesn't help.
Doesn't help. Yeah.
But worse than that, the form assumes he was convicted at the wrong court.
Yeah.
None of this helps much. Because the Court of Appeal rules don't provide for a different form for use in the Magistrates' Court.
The Court of Appeal hasn't got the file, so it doesn't know it was the Magistrates' Court. The Court of Appeal assumes from the form that it was a Circuit Court conviction, sends it to the wrong court.
Well, I think it says they're halfway tree resident Magistrates' Court, so they should know. But the point is, everybody does need to be very clear and focused on reading these things carefully and making sure that if you're going to use the same form for all appeals, that's fine, but you have to make sure, obviously, careful consideration is given to the contents of it. So what I say is, first, the Magistrates' Court should collate the record and send it as soon as notice of appeal is given, whether or not they receive Form B1. Secondly, if the Magistrates' Court or the Court of Appeal receives the grounds of appeal late, then obviously the defendant should be told, or his representatives, if there are any, should be told, we've got the form, it's either at the wrong court or it's at the right court, but it's late, and therefore your appeal is deemed abandoned.
If the grounds are sent late?
If the grounds are sent late. So that should be communicated, obviously, to the defendant. And then, of course...
I mean, are we to take it that that routinely doesn't happen? I mean, the question we asked your opponent was, are we talking about a sort of institutional problem or a one-off?
No, well...
The way you're putting it suggests this would happen regularly.
Well, I'm certainly not here on behalf of the government making that sort of decision. I'm simply making sure it doesn't happen again at all.
But you're being very helpful, because you're saying if you actually look at the forms
yes, and
the way this ordinarily happens, this is an accident waiting to happen possibly on a large number of occasions.
Well, I wouldn't want to be sick. I'm not here.
Possibly. I'm not putting higher than that, but what I'm saying is that...
This is my last ever instruction.
I'm seriously not trying to put you in a corner, but the way you're putting it is, if you look at the way the thing is structured, it could be said to be an accident waiting to happen.
Well, what I would say is, if you look at the way the thing that it is structured, it's very important that the Magistrates' Court and the Court of Appeal look very carefully at what is being sent to them and when. And if the grounds of appeal are late, it's obviously important that they communicate that to the defendant, so the defendant can then make a timely application to apply the proviso. And if the magistrate's court does what it is supposed to do, then the Court of Appeal will already have the documents, will already have the record, will have all the notes of evidence.
Yeah.
And if I'm right that the Court of Appeal, in deciding whether to apply the proviso, looks at the merits as well as the reasons for delay, then obviously it's important that it has the documents so that it can look at the merits of the appeal at the same time. I'm absolutely not. Yes.
I just want to take it back to a slightly anterior stage, and that is if the constitutional right or the right to have an appeal, which is as of right in this case,
Yes.
is real, not illusory, and the person isn't represented by lawyers when convicted, is there any obligation on the magistrate to inform of the right of appeal?
I would imagine so. I mean, it would be not a written obligation, but I would imagine it would be a responsibility of a court after somebody. But my understanding is, in the prison, I mean, in the appellant's affidavit, he refers to an appeal office within the prison. I don't think there's any doubt that once you're convicted, you go to prison, there's an appeal office. There are people there with forms, and they say, right, you know, and everybody knows that there's an appeal office, and you go along and you fill out your form.
Well, you've missed the opportunity of actually giving your oral notice of appeal in front of the magistrate if you don't know that there was such a thing.
Yes.
And I was just wondering whether or not, if the board indicated that there was an obligation on the magistrate to so inform a person who hadn't got legal representation, whether that would be a step too far.
Well, perhaps I take instructions on that over lunch. Doesn't seem to me particularly controversial, but especially if somebody's pro se, obviously I'll take instructions over lunch. But I'm not suggesting on any sense at all that this happens on a regular basis. There have been cases where it has happened. It doesn't matter if it happens once or twice, or never, or hardly ever. It's important that a system is put in place and guidance is given to make sure it doesn't happen at all. But on that same vein, it is important to recognise, and to dig myself out of a hole if I can, but to recognise that the authorities in Jamaica do obviously realise that it's important to implement Section 296 of the Parish Court Act in a way, in a fair and rational way. Because in other words, Section 296 of the Parish Court Act says a defendant must file their grounds of appeal with the clerk of the magistrates' court. Obviously, if they're in prison, they can't do that. So what the executive has done, sensibly and rationally and fairly, in my respectful submission, is they have developed a practice whereby the authorities within the prison pass out forms and then take on the duty to take those forms to the right court. So the idea and the practice is all there, and it's constitutional in my respectful submission, and there's no need to read words into or out of Section 296 because the state already does what it should. In other words, to give effect to what Parliament is trying to achieve by Section 296, the executive has developed that practice.
Sorry, how does the practice you describe give effect?
Well, Parliament has, first of all, in Section 293, given a statutory right of appeal. In order for that statutory right of appeal to be meaningful, people who are incarcerated need to be able to exercise it. Section 296 says the way you exercise that right of appeal, first of all, you file your notice of appeal and then you file your grounds under Section 296. So that's how Parliament says an inmate can exercise his right of appeal. But that exercise is futile unless the state actually provides a mechanism by which Section 296 can be fulfilled. But that's not, in my respectful submission, a question of constitutionality. It's just box standard public law. The executive is required to fill the gaps and make sure that these statutory rights are actually effective.
Just going back to the form of page 21. At the bottom of the page, it refers to Form B2 and a time limit of 14 days. Do we have Form B2?
We don't have a copy in the fund, or let me just...
And Form B2 wouldn't address the time, because you have 21 days, don't you, to put in your grounds of appeal?
You have 21 days from the date of judgment, yes.
Yeah.
So that's really all I have to say on sort of what went wrong and what might be said in order to make.
And if you look at the bottom of that page, if the notice is signed more than 14 days after conviction or sentence, rather than being filed or delivered, it's a little bit misleading, is it?
The courts that are obviously handing out these forms and receiving them are well versed in how this stuff operates. As my learned friend says, the clerk of the courts is a practicing prosecutor, and therefore everybody knows these time limits and knows what needs to be done and by when. It's just a matter of ensuring that they're read carefully and that the system itself is maintained and upheld. But the reason why I say all of that, of course, is because the next submission, the second issue, of course, is, well, there is no constitutional imperative, I say, to read Section 296 in the way contended for by the appellant.
Perhaps we'll come to that at 2 o'clock.
2 o'clock, thank you very much.
Thank you, Mr. Benjamin Benton.